Okay. Jyoti Prakash, you can continue with
Yes.
the formalities of this session.
Yes. Thank you, Devasis. Good evening, everyone. This is Jyoti Prakash Datta, co-founder, Team Lex Cognoscenti. So we have come out with this initiative that is known as Lex Cognoscenti Rendezvous. The basic purpose behind this initiative is to provide the well-experienced person's experience to each and everyone, so that everybody will be able to know something basics about the legal systems. So we always try to bring some experiences of different experienced person like senior advocates, high courts, and other advocates as well as advocate on records. So today we are with another renowned personality. He is Mr. Goutam Kumar Acharya. He is senior counsel, Orissa High Court. He has decades of experience at the bar. So we are very pleased to have him today with us in this evening. We are very pleased to have you, sir. Welcome on board, sir. And Devasis, first phase, the Devasis will take the interview, and I will come in the second phase. So Devasis, you may continue.
Okay, thank you, Jyoti Prakash, for a brief introduction of our organization, that is Lex Cognoscenti. So before going into the intricate questions that we will be discussing today with Goutam Acharya sir, uh, I will I will take this opportunity to introduce him briefly to all the attendees who are viewing our channel, who are viewing this particular interview. So Mr. Goutam Kumar Acharya is a renowned advocate, senior advocate. He has been litigating for more than 3 decades by now in various forums all across India. He primarily practices in Orissa High Court. However, he regularly appears in Supreme Court of India, Delhi High Court, Calcutta High Court, Bombay High Court, and many other forums quite regularly. And he has dealt with multifarious cases, which include a wide range of laws like mercantile law, company law, banking law, insurance law, contract law, and there are many foras of law which he has already dealt in a number of cases. Now, to mark this particular thing is that he has been the counsel for many public sector undertakings like BHEL, then EPICOL, OPGC, OSIC, OSFC, CCL, and many other state public sector enterprises. He has also represented several banks before the Supreme Court of India, like HDFC Limited, State Bank of Hyderabad, and UCO Bank for several years. Now, till date, he has mentored almost 40 of his juniors who have started their independent legal practice successfully before various high courts and Supreme Court of India. And apart from representing manifold clients, he is the standing counsel for the Controller and Auditor General of India and Accountant General Odisha in Orissa High Court. And there are few leading cases which we will be discussing with him today, and he will be elaborating upon those cases which are of public importance to us. However, I would just like to name a few of cases which I know, which I have researched, and sir has also given me leads about those cases. The first one being Arun Kumar Budhia versus State of Orissa, and another where the Orissa High Court ordered that uploading of FIR in the Orissa police website is mandatory with fewer exceptions. And the second case is Anita Budhia versus State of Odisha, wherein Honorable Orissa uh, High Court file ordering in favor of the petitioner dictated that the state government shall establish PET CT scan machines at Acharya Harrier Medical Institute and other hospitals all across the Odisha. So these are quite landmark cases which we all must know, and which were represented, and the petitioner were represented by senior advocate Goutam Kumar Acharya, and we have him today for the today's interview, and he will be discussing with us his early childhood career, witty conversations in which he has involved or he has witnessed in Supreme Court, as he has wide span of continuous practice of 15 years in Supreme Court, and he still regularly appears there. So I am sure that there must be a lot of witty conversations, humorous conversations, or remarkable conversations which he will be sharing with us. He will also share with us the ideas, the roadmap of success for young law students and young generation lawyers, and what are the importance of moot courts, internships, and then how one should practice, what qualities he should inculcate, and a lot of things. So, without any further delay, I would like to begin the interview with the permission of sir, if you may allow, sir.
Definitely. Thank you so much. So before I start my conversation with your team and going live, I would first thank you for giving me this opportunity to place my facts and my experience before this audience who are on the virtual mode. Before I start, I would like to highlight one thing. In my entire career of more than 30 years in this legal profession, I have never attended any seminar or given any interview for that matter, because I'm a very, you can say, unsocial person, or I'm a very introvert kind of a person. But the moment you told me that this particular session is with regard to giving tips to the younger generation of lawyers and the law students, then I thought it is my primary duty to inform them as to what are the techniques one should adopt in becoming a successful lawyer, or for that matter, for being a sound lawyer. And this experience, which I have gone through in my past 30 years of practice, starting from the initial days of my practice, I want to share in this platform. So that was the primary reason why I accepted your invitation, though initially I had refused. And that is how I am before you people.
Thank you so much, sir, for consenting for this particular interview. So, beginning with the very basic and the first question, which we all would like to know, is that about your childhood and schooling, and how were your academic careers, and how what memories you have of your childhood and schooling, which we all can know.
Okay. To start with, initially, first I started my education career in St. Joseph Convent School at Cuttack. Though right now it is basically a girls' high school, but during those days in late 60s when I had joined, so it was a co-ed school. I studied there for an year or so, and thereafter, my father being a doctor, he was transferred to Berhampur Medical College. So I was given TC from that school. Then I went to Berhampur with my parents. I studied there in that Berhampur convent school for till the standard 6th. Thereafter, again, my father got transferred back to Cuttack. And that is how again we came back to Cuttack, and I was admitted in the Ravensa Collegiate School, which is a very old and famous school, more than 100 years old, where a very luminary person like Netaji Subhash Chandra Bose and many others have passed out from that school. So I had that privilege of studying in that school from 7th till 10th, and I passed out in the year 1981. I would just give one slide, one simple experience of mine while studying in that school. Because till 7th standard, I was in an English medium school, both at Cuttack and Berhampur. When I switched over to a Oriya medium school, I was like a fish out of a water. So I really didn't have much of experience as far as Oriya language was concerned. And to top it all, so they had a subject called Sanskrit, which was absolutely a foreign language for me. Anyway, I just started attending classes. Maybe after a month or two, we had that half-yearly exam. So in that half-yearly exam, so there was a Sanskrit paper, and the paper was given to all the students to write. So it may sound very funny and funny in the sense, because when they get that language was in Hindi, though it's a Sanskrit language, the alphabets were in Hindi. So I really didn't know in which language, in which alphabet form should I write the answers. Should it be in Hindi or Oriya? So I started writing in Hindi for a moment, maybe for 2, 3, 4 lines I started. Then I got confused. I thought, I'm not doing the right thing. So then I just looked around to my side, some classmates, and in what alphabets they were writing. So then I saw they were writing in Oriya alphabets. So then I realized, no, the Sanskrit, though the medium is Hindi kind of a thing, but while writing, it has to be written in Oriya alphabets. So that was an experience which I really gained or had, and I still continue having that experience. And wherever I get a chance to, I always explain this fact to my friends and other well-wishers. So after passing out from Ravensa Collegiate in 1981, then I joined Ravensa College. That time it was college, it was not a university as it is now. So I did my intermediate commerce. Thereafter, I did my BCom honors, and I passed with distinction with honors in 1985. That was as far as my college life and the school life goes.
Absolutely, sir. These little things of childhood always stay with us, and we will always recapitulate and recollect those things and share with our kin and kids. So that's quite wonderful to hear that. Now we have seen a recent trend that uh, what students do is, if they are not getting medical, if they are not getting engineering, the third option they choose is to do law in law colleges, and they decide this particular thing quite in a late term, I would say, after their plus 2 boards. So this brings me to ask you a question, that at what age you decided to pursue law as your career?
To be very honest with you and with the audience, I never had any interest as far as law was concerned. So, like as you rightly said, in those days, when people had the first preference of going in for medical or engineering, these were the main two fields in which most of the students they were interested, and the parents were also forcing the students to go in for those subjects or the courses. But some, because I was from the commerce background, so I didn't have that option of going in for engineering or medical. So but at the same time, I never had any interest or inclination as far as law is concerned. So I just took it as a what you call a vocational study kind of a thing. So I enrolled into the chartered accountancy course. And then simultaneously, I also enrolled myself for the law course, and I passed my law from Madhusudan Law College in the year 1988. And in between, I was also doing my master's in commerce, which I passed out from Utkal University through the private mode. So that is how, I mean, I did my law in 1988. But till such time, I had never thought in my wildest of dreams that I will become a lawyer one day.
But then, as we all know, and as we see that you have become a great lawyer, absolutely a great lawyer. So even though it was by chance of doing law, you have gained a lot of experience. You have represented represented in a lot of important cases. So having said that, I would like to know if there was somebody in your family who was in this particular legal field or who was practicing law at that time.
First of all, I would like to clarify one thing. I'm not a renowned lawyer nor a great lawyer. I'm just a lawyer. I have to be humble enough to accept this fact. So it is your kindness, or you can say your greatness, that you have added this adjective before my name. But anyway, and that apart, as far as the family background of mine is concerned, from my paternal side, so most of the people, they were from the medicine background. My grandfather was a great Ayurvedic doctor. Then my uncle is an Ayurvedic doctor. My cousins are Ayurvedic doctors, and there are n number of doctors in our family from the paternal side. But as far as the maternal side goes, my grandfather was a leading lawyer in the early pre-independence and post-independence. And in 1959, he got a chance to become the High Court judge, and he was posted at Patna. In fact, he was the first person from Orissa, after the formation of Orissa High Court, to be appointed as a judge at the Patna High Court. So he served there from 1959 till 1967, and thereafter again, so he was reappointed by the President of India, because there is a particular provision under the Constitution of India for reappointment in case of there is exigency or requirement of judges, and the President, with the consent of the retired judge, he can be reappointed. So that was the basic formula behind this appointment. And my grandfather, he again got reappointed as a judge of the Patna High Court for another further period of 2 years. So in all, so this was the basic thing which really motivated me for being a lawyer. Because, and another thing I would like to highlight, he has written a book. I'll just show you this book. The book, if you can see, this book says "My Life and My Work," written by Justice Haryar Mahapatra. Is it visible? So this is the book. So he has written.
Yes,
This is not exactly a autobiography, but he has penned down his entire career, starting from his childhood till his retirement and post-retirement, what all activities he has done. So there, this book was published sometime in 1987, and I got a chance to read this book sometime in 88 or 89. And after going through this book, it really inspired me as to what are the benefits of becoming a lawyer and how you can help the society at large. So my main source of inspiration is my grandfather, late Justice Haryar Mahapatra. And that is how I am before before this audience as a lawyer.
Absolutely. As we can see, your grandfather has played a great role in shaping you and introducing you to this particular legal profession and legal field. That's quite a great story of inspiration that you have just said. Now, as you said that you were studying, you have studied from Madhusudan Law College. So I would like to know that how was your alma mater at that time? Because it has immensely changed if you see it today.
To be very honest and frank with you, in those days, as I told you just a few minutes back, law was the last resort for any student because that was not being taken as a primary career for any student to be continued in future. So the same thing also applied in my case. So what I did, though I got enrolled as a law student in MS Law College in 85, but to be very honest with you, till 88, I never attended any classes. That was the absolute normal practice at that point of time. So in that entire 3 years, to be very honest, I never attended a single class. And though I'm going to say it on record, but the fact remains the fact. So when the exam used to happen, those days we used to have a book called Allahabad Law Series. So that book was widely circulated and very popularly available in all leading bookstores, and it was very nominally priced. So just before the day of the exam, so all the students, they used to carry this Allahabad Law Series book depending on what subject the exam is scheduled for, and the books were allowed in the MS Law College at that point of time in 80s, and it continued for quite a bit of time. And that is how I sat for the exams, and I was not the only person. It was in fact the entire class of my batchmates. They followed the same practice, and we all passed. And the second interesting part is, so because everyone used to copy from the same book, from the Allahabad Law Series, so my personal experience is, and many of my friends have also shared their experience, saying when the results were out, everyone used to get 50%, 50, 51, 52, like that. And all used to pass. And there was a rumor or a rumor going around those days saying it depends on the weightage of the answer sheet, and the marks used to be awarded. I don't know how far it is true, but this is what I have gone through. So practically, I didn't have much of contact as far as the teachers were concerned and the overall curricular activities of the college.
You have rightly said that at those time in 80s, 90s, people used to have law colleges used to have open book system, if we term this particular process as such. So, but now that has greatly changed for today's legal education is concerned. So, however, as you said, you were not involved much in Madhusudan Law College. But still, I would like to put for this question that if there was any particular law subject which fascinated you at that time. For example, if as I am studying law in University Law College, I am quite fascinated with criminal law and intellectual property law. So if there was something same with you at that time.
Again, to answer this question of yours, because I was never seriously taking up this law course, and again, to be very honest, I didn't have much of ideas ki what all subjects we had in first year, second year, third year. So the forget about what topic would have fascinated me. So I'm being very candid actually. So I in fact during that entire 3 years of my duration in the law course at MS Law College, I never had any particular fascination or interest for any particular subject, because the rider is because I never wanted to be a lawyer in future. So this course I had just attended just to have an additional degree, because I was doing simultaneously my chartered accountancy course. So my priority was CA, not law, but I was just pulling on.
Okay, sir. So now, as you have practiced for almost 3 decades, 30 years by now, so you must have seen a great change in legal education. As one pointer, I have already said already. So if you can address us as to how legal education has greatly changed since your time.
Now, there have been drastic changes as far as the legal system is concerned, not only in Orissa, in the entire country. Particularly those students, those who are going in for integrated law, 5-year course. So they just cannot take it as a ride actually. So they have to be really serious with the course and the subject. They have to attend classes regularly, and they have to be at it. Otherwise it's absolutely impossible for passing the LLB 5-year integrated law course. And so one has to be very thorough in all the subjects, and he has to be at it throughout the entire 5 years course. But whereas in our days, that was not there. And simultaneously, now, forget about the reputed law institutes or the law universities, even the normal law colleges of not that high reputation, those who are giving 5 years integrated courses, they are also making it mandatory for the students to have their regular classes and sit for the exam. That open book system is gone now. You have to prepare yourself and sit for the exam and pass the exam. Otherwise, it's absolutely impossible. But as far as the 3-year law courses are concerned, to my knowledge, there are quite a few institutions or colleges for that matter. I'm talking about Orissa, plus also outside Orissa, because I have known a couple of friends of mine, those who have passed of late the 3-year law courses by adopting the same means which I was doing 30 years back. But again, there has been some improvement. Now, as far as the classes, attending the classes, it may not be that important. You may not attend the classes, but you have to sit for the exams, and you have to apply your mind, go through the books, and write the exam. You cannot carry your books and copy it. So that has already gone. So this is a good sign. So that in this entire process, as of date, so we have a better chance of having brighter students coming up into the law profession as was there 30 years back or 20 years back. So it's a big help to the society at large and for the law students in particular.
Indeed, sir. The system is quite changed by now, and you have rightly pointed out the great changes since your time and nowadays. Now, as I already said to our audience, that you have an immense experience in this legal field, and moot courts are getting traction nowadays. There are various competitions going on between law students and law colleges. So, if we can tell us the importances of moot courts for the fresher or junior students who are viewing this particular video.
Again, to be honest, I have never attended in any moot court, either as an audience or as a judge, or for that matter, in any form. But the fact remains, the moot courts are a great help to the law students in the present generation. Because if you want to be a successful lawyer, there are 3 stages. One is drafting, second one is research, and then third one is pleading. So these are the 3 stages which one has to go through sincerely if you want to be a successful and a good lawyer. So by the help of these moot courts, if a person is participating in any of these moot courts, either conducted by the university, colleges, or for that matter, interstate or whatever it is, so they get a tremendous scope as to how they can improve themselves in all these 3 fields which I just told you, starting from drafting, research, and placing the facts and arguing. And not only that, that will also give them a very big moral boost to develop that confidence, because in the moot court also there will be judges, dummy judges, before whom they have to place their case and facts, and there will be an opposition side also. So they will also be countering the allegations and counter allegations. So that really gives a real big moral boost for those students who are participating in the moot courts. And in my opinion, it is highly desirable and essential for all the law colleges to have as many number of moot courts, and to ensure that the students participate in those moot courts either on it cannot be voluntary. They have to be forced. It has to be made mandatory that they have to participate. They cannot be given a choice whether you should participate or you should not participate. The more they participate, they get the more exposure towards the legal system, and they'll also learn the court craft. So in my opinion, moot courts are very, very essential as on date.
Indeed, sir, as you rightly pointed out, that drafting and then framing of arguments and oratory skills are very much required for a law student and an advocate also. So I would like to just highlight this point for our audience, that the students, if they are at all viewing, they should start doing moot courts. There are a number of moot courts, and they will obviously give a huge exposure, as Goutam sir already pointed out, for this field, and you will be ready for joining this litigation field as soon as you pass out from your college. So now the next question that comes to my mind is that, as you already said, you have started practicing in 1990. So, how were your initial days at the bar?
Well, as I told you, I passed out in 1988, but I started my practice. I got my bar license in 1990 after 2 years because I was still in a fix. As I told you a few minutes back, I went through the book written by my grandfather, and that inspired me. And I made up a mind that I should forgo this CA course, though I had not completed by then also, and I would stick to the legal profession. And I decided to start my practice at the highest court, that is in Supreme Court. In 1990, I got enrolled at the Supreme Court and I started my practice. In those days, there were hardly any Oriya lawyers in Supreme Court, maybe maximum 5 or 10, including myself. So it was absolutely a gray area as far as the Oriya students or the Oriya lawyers were concerned. So I just started my practice there, and to be very precise, I practiced there under a senior, rather two seniors. With one senior, I worked for 2 days. I left that senior because my mentality and his way of approach towards the senior, towards the junior, didn't fit me. So I thought, no, it's not my cup of tea. So I just left that senior into. I'm not naming that senior. He was a very renowned senior practicing on the taxation side. I left him in the second day itself. Then I joined another senior, because in Supreme Court, the process is slightly different as compared to the High Courts. In Supreme Court, we have got advocate on records and arguing counsels. Arguing counsels can be senior advocate, designated senior advocates, or advocates by n number of experiences at the bar. So I joined an advocate on record at the Supreme Court as a second senior of mine in my legal profession. There also, I had very bitter experiences. So again, it did not suit. I'll tell you the experiences which I shared with these two seniors in just a moment. So then again, I decided, no, I cannot continue with these seniors. It's not my cup of tea. I have to mend my own ways. I have to find my own sources. Now, I'll tell you, for the younger lawyers and the law students, this is very relevant, and they should mindfully hear to what I'm trying to say. It is very important for a law student or for a young lawyer who has just passed out from the law college, has enrolled himself at the bar and wants to enter into a practice. So the thing is, you have to find out a right senior who is going to guide you and who is going to really help you in all matters pertaining to the legal field. Now, coming to my case at hand, when I first joined the taxation senior, it was my first day in office. I didn't know anything about Supreme Court because I just had a mindset, I'll go and practice at the highest court of the country. I went to Delhi, and in 1990, it was a very, things were not that advanced. The technology was also not that well advanced. So the first day I joined that senior, so there he had a huge office in South Delhi, and he had about 8 or 10 juniors at the different stages of practice. So the first day I joined there, so one of the senior-most juniors, he gave me a brief. That brief in Supreme Court, when you file a case, like in High Court, when you file a case, it is called a writ petition. But when a case is filed in Supreme Court, it is called special leave petition. That time, I didn't know what is the full form of special leave petition. That was my depth of knowledge as far as law was concerned and as far as Supreme Court practice was concerned. He gave me that brief. He said, Mr. Acharya, please go through the brief. And you have and the process in Delhi Senior Counsel's office is the juniors, they have to first go through the briefs, make notes, and make the pointers of the brief and mark it, and then brief the senior counsel, who in turn will go and appear before the concerned court. So this is the practice in Supreme Court, though this is not strictly followed in a Orissa High Court. I'll come to that later. So I was given a taxation brief. I was asked to go through it, and the brief was given to me around 10 or 11 in the morning. And we had this group discussion with the senior counsel at 4 in the afternoon. So at 4 in the afternoon, so all the juniors were together along with the senior counsel. The senior-most junior who had entrusted the brief to me, he asked me, okay, what all have you learned from this brief? What all are the main pointers? You have to brief the senior. So I didn't know ABC of income tax, forget about special leave petition. So I was frantically worried. I was almost in tears as to how will I face myself before the senior. Somehow or this senior could feel my situation. He said, okay, doesn't matter. you come prepared tomorrow. Again, here I would like to state the senior was at great fault. He should have seen, okay, this person is a fresher. It was his moral duty as a senior counsel, having put in almost 30, 40 years of practice at that point of time, to have guided me. Okay, no, this is not the way how to handle a brief. First, if a special petition has been given to you, first see under which provision of law the case has been filed. Because it was under the Income Tax Act, the case which I was referring to. Now, supposing let us assume 146 of Income Tax Act, Section 146 of Income Tax Act. He should have guided me. No, first you take the Income Tax Act and the rules. Go through that relevant provision. What does it say under the Act and the rules? Then try to analyze that particular provision in the grounds we have taken in the petition. By doing so, one can have a broad mindset, a broad outlook as to what has been written in the petition and how we are going to place the facts, which was never given to me. So that is where the senior grossly went wrong in handling his junior. So which forced me to leave. I said, no, this is not a office where I should appear. This was my first instance. Then I come to the second instance. Then I got myself enrolled in another office of an advocate on record. He was also a very prominent advocate on record. There also I faced the same similar situation. The first day I joined his office, maybe on the second day or so, he gave me a brief. Normally what happens in Supreme Court, the brief normally comes from different state high courts by way of an appeal, which is called special petition. So in that particular office, a brief had come from a particular state. So that brief contains the High Court judgment, the writ petition copy, the counter affidavit, etc., and all the connected documents. So the senior tells me, okay, you take this brief, draft the SLP. So I took that entire brief with me to my house. I was staying as a bachelor then. So it took me almost 2-3 days to figure out what I'm to write, where to start, where to finish, and how to go through that judgment to decide what all are the points relevant for the purpose of drafting this SLP. So after 3-4 days, I just couldn't find out head or tail out of it. Then finally on the 4th or 5th day, the senior comes back to me in the sense I was in the office. He asked me, Goutam, have you finished that drafting? I said, no, I haven't finished. Then he started scolding me. Why haven't you done? Of course, though I didn't tell him at that point of time what went wrong with him by handing over this brief to me, but I realized within myself the fault of the senior. He may be a senior, but at least it was again his moral duty to inform or to guide his juniors. If you really want to keep someone in your chamber as a junior to assist you, then it becomes a moral obligation to see that the lawyer learns something in return. Because those days also, the remuneration was just paltry sum. I was just getting about 2,000 rupees, I think. I'm talking about 1990. So 2,000 rupees in Delhi was hardly anything. But anyway, that was the thing. So this is where the senior again grossly went wrong. So my point is, when you start a practice, whether it is in Supreme Court or High Court, you have to choose the right senior and see that he really looks after you professionally so that you derive some knowledge out of his own senior's experience, which I really failed to get. So that is how again I left this senior and I decided to be on my own. This was my initial days of practice as far as my seniors were concerned.
You rightly pointed out 2 things here. I would like to just give that to our audience in brief, that a junior or a fresher law student should always choose a right chamber for him, so that that particular senior will guide him throughout his journey and will encourage him, will give him boost, will act as a teacher sometimes when the junior doesn't understand a particular thing. So this is a very important and pivotal point you rightly said to me. Now the second thing, you have also told that what are the challenges that you have faced in your initial days in the Supreme Court. And you were also speaking about the practice in Supreme Court. Now this brings me to the question that if you can highlight the practice in Orissa High Court, because you have also spent a significant year of practicing here in Orissa High Court. So if you can just give our audience a difference between both the practices.
Before I answer this question of yours, I just want to add one more thing of my past experience in the initial days of the Supreme Court. What happened? The second senior whom I left, I should be grateful to him to some extent, if not 100%, to some extent. The reason being, it was just hardly a few days of my practice in Supreme Court. He asked me, okay, Goutam, you go and appear in court number 3. I still remember that court. It was court number 3. I'm just forgetting the judge's name. He said, you take this brief and you appear. That was my first day of appearance in Supreme Court, or for that matter, any court, as a lawyer in practice. So the moment I started, went and appeared before the court when my matter was called, and you won't believe, I'm really feeling very funny describing this fact. My legs were literally shaking because I didn't know how to address the court. But I should be grateful to my senior to this extent that at least he gave me that opportunity to appear and place the fact. And I did so. I could fairly do well, but initial few minutes was literally jickery for me. My legs were literally shaking, as if I was feeling as if I'm going to collapse any moment of time. So that was another experience of mine. Now coming to the practice at Supreme Court and Orissa High Court for that matter, there is hell and heaven difference. In Supreme Court, or for that matter in Delhi High Court, because I practiced in Delhi High Court also for many years. So there, everything is very systematic. You don't have to do anything. You don't have to do a lot of follow-up as far as the registry is concerned. Because when you talk of practicing, again, there are different stages of filing. First, a client will come. Once the case is ready, once the petition is ready, either you go yourself, if you don't have the proper infrastructure, or you engage, if you have a advocate's clerk or a mohri, whatever you call. So he has to go and do the filing. In Supreme Court, the system is so systematic. I'm talking about 30 years back. Now it has still improved. The moment you file the petition, the SLP or the writ petition, these are the only two main formats of filing in Supreme Court. When you file these petitions, that is first scrutinized. Once it is scrutinized, then they will point out the defects. What all are the shortcomings in the petitions? And they will ask you to remove those shortcomings. And once those shortcomings are removed, then the petition is ready for numbering. Once the petition is numbered, automatically on the 15th day or maybe on the 16th day, around 2 weeks, the matter gets listed before the Supreme Court. You don't have to do any running around. You don't have to spend a single pie, or you don't have to make any kind of request before any of the registry officials or the staff, or starting for that matter for the peon also. The same thing also applies to the Delhi High Court. In Delhi High Court, there is a slight difference. That point of time, I am not able to tell you exactly what is the present scenario. Like in Delhi High Court, if you want to file a writ petition, or for that matter, any petitions, if there is any urgency, you have to file an urgent application along with the petition. In that urgent application, you have to give the reasoning as to what is the urgency for your matter to be listed out of turn or on an urgent basis. And for that matter, you have to fix a requisite amount of court fee. That court fee was very nominal. That time it was around 202 rupees 50 paisa. I don't know how much it is right now. So once that urgent application is filed along with the court fee, then automatically the matter gets listed the second day if there is no defect. Do you get my point? So once there is no defect, the matter is registered and it has been allotted with a case number. Then on the second day, the matter gets automatically listed. This is as far as the Delhi High Court is concerned. When you talk of Supreme Court, it used to take 15 days, that is 2 weeks in those days. But now, coming back to Orissa High Court, because when I came back from Delhi after having put in almost 2 decades of practice there, I really felt fish out of water. Here, everything was in a mess. They didn't have any proper, I am sorry to say this, maybe some of my colleagues also must be hearing this broadcast, but fact remains fact. That cannot be anything which cannot be disclosed. The thing is here, when you file a petition, at every table, because of when you file a petition, it has to go through different stages of filing. Different persons are assigned with certain amount of tasks to go through those petitions, to scrutinize, to point out the defects and how to remove the defects and all. Every table, the concerned person has some interest. I'm not elaborating on that. You can guess what I'm trying to say. So until unless that interest is fulfilled, your things will not get work. So in the initial stages, when I used to send my staff for filing the matters, at the end of the day, he will come and give me a sheet of expenses. I used to ask him, what are these expenses? Then he used to just justify the reasons and what are those expenses meant for. So this is one. which is a very bad thing, and still and till date also the same thing is continuing. It's very unfortunate actually. Steps should have been taken by our own bar, or maybe from the court themselves. They should have taken steps to ensure that the same system should follow as being followed in other states. So that is not being done. This is one. Another most important thing which I found there being drastic difference as far as filing and listing of cases is concerned. Here, even today also, when you file a case, there is no system like urgent application. Here, what you do, you have to file a petition. Then you have to give a memo for listing of urgency, showing the urgency. That memo has to go before the deputy registrar. Then it is at his discretion to either to allow the memo or not, or you have to go to the court, and court has to decide. So this process is very cumbersome, and it's a very toiling effect on the lawyers who do not have that kind of an infrastructure for sending the juniors or their staff for getting these things done. It is a very difficult thing. Had the court so moto decided, okay, like Delhi High Court will apply some amount of court fee for the urgent application, and the matters can be immediately listed. So this would help not only the lawyers, the matters would have been simplified to a great extent, listing would have been much better, and the level of untoward demands would have drastically reduced. These things should have been done by our Honorable High Court. And I wish, because our present Chief Justice, he having come from Delhi and he having practiced in Supreme, I was also practicing there when he was a lawyer out there. I hope he will take up this matter seriously and see how things can improve, so that ultimately the lawyer community at large and the clients will also be benefited. That's what I have to say as far as the practice mode is concerned.
Indeed, sir, very correctly pointed out about the differences in the practice and procedures in the Supreme Court and Orissa High Court and other high courts, as you said. And the turmoil, or I must say the backward thing that is going on in high courts should be recovered, should be rectified, as you said. And they should rectify all these legal systems so that it will be a better experience for a lawyer as well as judge and other persons associated in this particular field, be it a law clerk or anybody. So I think it will be rectified soon. And even if I join bar and in the future, if I would surely try to do something in that regard also. So this brings me to my another question, which is also most important question I would rather say for us to know the leading cases or landmark cases as per you in which you have appeared. In the introduction, I have said about Anita Budhia and Arun Kumar Budhia's case. If you can elaborate on those two cases, and if there are any other case for our audience that they should know.
As far as the cases are concerned, for a lawyer, all cases are of equal importance. We cannot say that this case is of primary importance, this case has significant or less significance. It should not be distinguished that way, because for us, all clients have equal status before their lawyer. And we should also deal with them in the same manner as we deal with a high-profile lawyer or high-profile client or a corporate client. So this is very much essential. So, but however, I have done many cases, but it needs a lot of time to elaborate on all those cases. But I would just like to highlight on 3 cases which are of public importance, which has helped our state of Orissa people at large, and they have been benefited to some extent. The first case being the uploading of FIR. If you see, as you being a law student yourself, and the young lawyers also, they must be knowing, under the Criminal Procedure Code, there is no provision for giving a copy of the FIR to the accused. It is only under section 207 of CRPC. An accused is entitled for a copy of the FIR once the charge sheet has been filed in the court. Once the charge sheet is filed, then is entitled for getting the entire case records, including the copy of the FIR, charge sheet, and all relevant documents for him to prepare the case. So what used to happen till we filed this case sometime in 2011, I believe. So because this process was not there, now supposing a person has been named in an FIR. So what is the remedy available to him under law? He has to go and file for an anticipatory bail, either before the Sessions Court or the High Court under section 438 of CRPC. So now when you file an application for anticipatory bail, you have to attach a copy of the this FIR, Because until unless you file a copy of the FIR, how will you place before the honorable judges what are the allegations leveled you against you in the FIR and what are the sections involved? So for that copy of the FIR is mandatory. So now what is the process of getting the copy of the FIR? So the process is either you go and apply through a lawyer, apply for a certificate, file your appearance in the court below where the FIR has been lodged, and you file for a certified copy. And it's a lengthy process and it takes a lot of time. Now, to counter this process, what people used to do, they used to somehow or the other get a copy of the FIR. I'm not elaborating how it is obtained. That is for the viewers and you to decide and just visualize what was the method adopted. So we felt that there was a genuine necessity of removing this hurdle so that the persons against whom the FIRs have been lodged, they are benefited. So we filed a writ petition in the Honorable Orissa High Court titled Arun Kumar Budhia versus State of Orissa, and Union of India was also made a party to that. So there we made a specific allegation, not allegation, a specific contention was raised because there is no provision under the CRPC except 207, and that 207 only comes into play after the charge sheet is filed. Hence, there should be some direction given by the court for a copy of the FIR to be given to the accused person or the persons named in the FIR. And we also stated why is the copy of the FIR necessary for the person concerned, because it is his fundamental right to approach the concerned court having jurisdiction for grant of anticipatory bail. So it is his fundamental right, and to overcome and to have his fundamental right executed, so this copy of the FIR is needed. So that is how we filed this case. And the Honorable High Court, after an elaborate hearing, finally came to the conclusion that whatever stand we had taken in a petition, that should be allowed for the benefit of the persons concerned, looking at their right to life and fundamental rights. And finally, that petition was allowed. And the court directed that the Orissa police should upload the FIR within the 24 hours of it being registered. But however, there were certain riders to that judgment saying the cases of sensitive nature, for that matter, supposing let us assume 376 involving rape and cases involving national interest, security interest. So those kind of cases should be removed from that list of cases which are to be uploaded. So the case was allowed in our favor, but the state government did not accept that judgment passed by the Honorable High Court. They went in appeal by way of SLP to the Honorable Supreme Court. But the Honorable Supreme Court, again after hearing us, upheld the decision given by our own High Court, and that has become the law of the land. So now, since then, the FIRs are being uploaded within 24 hours in the Orissa Police website, not only in Orissa, in the entire country, because now it has become the law of the land after the passing of the judgment by the Honorable Supreme Court. So every person, those who have been named in the FIR since then, have been benefited, and lot of corruption has also been sidetracked, which was otherwise just getting momentum. So this was a big relief for the persons at large. This is as far as the first case is concerned. Then I come to another case. This is a case relating to cancer patients. So now here what happened. So one of my friend's wife, she was suffering from cancer, and she was in the last stage of her life due to this severe infection of cancer. It was the fourth stage of cancer. She was admitted at the Acharya Cancer Institute. And unfortunately, though it is one of the regional institutes of Orissa and the main institute in Orissa as far as cancer treatment is concerned, but they do not have a PET CT scan. And PET CT scan is a very expensive mode of testing. It costs about 25,000 per test. So how many persons in Orissa can afford to go for a PET CT scan? And secondly, you do not know how many number of times a patient has to be asked to go for PET CT scan. In this particular case, which I'm dealing with right now, that patient was asked to do PET CT scan for 4 times. So that means he had to spend almost 1 lakh rupees. And here also what happens, there are only very limited centers where PET CT scan is available. For that matter, in Cuttack and Bhubaneswar, only 3 centers are there which are providing this facility in the entire state of Orissa. You can imagine how difficulty the person suffering from cancer would be facing to have this test done. So we filed this case. So when we filed this case, notice was issued to the state of Orissa, and now the matter is still sub judice before the Honorable High Court. But I can tell the latest position. I'm not drawing any conclusions. But luckily, what has happened after notice was issued by the Honorable High Court, the state government has come forward and has given an affidavit confirming that they are going to install the PET CT scan at the Acharya Cancer Regional Institute at Cuttack within the next 6 months, because our infrastructure is already ready in the PPT mode. So that is as far as the Cuttack Center is concerned. Plus, they have given another affidavit saying that they are in the process of installing the same PET CT facility at Jharsuguda, where a 100-bedded cancer institute is being set up by the state government, and one at Bhubaneswar near Capital Hospital. So these two other centers at Jharsuguda and Bhubaneswar would take about another 2 years' time for being operational. So now we were not satisfied with the affidavit given by the state with regard to setting up these centers, because the point raised by the state in their affidavit was the chemical which is used for testing of this PET CT has a lifespan of about 7 to 8 hours. So they placed before the court, because this, I think it's, I'm just forgetting that technical term. I'm just not able to recollect that term. Anyway, that particular, you can say medicine or that chemical has a lifespan of 7 to 8 hours. So they took a stand where a commercial airport is situated. So only near that area, this PET CT facility can be availed. Because there is a commercial airport at Jharsuguda, so they have preferred Jharsuguda, and there being an airport at Bhubaneswar, one at Bhubaneswar. To counter this stand of the state, we said, as you have said in your affidavit, that the lifespan of this particular product and drug is 7 to 8 hours, and there has to be a commercial airport. If for that matter, if we go by your own affidavit, let us assume Baleswar. Baleswar is about 3 to 4 hours driving time from Kolkata. Why not have a center at Baleswar? Because now there is a medical college also out there. And why not we have one at Barampur, which can cater to the southern part of Orissa. And Barampur is just about 2.5 hours drive from Bhubaneswar. So these points were appreciated by the Honorable High Court. And now the court has further asked the state government to file an affidavit and to place before the court on the next date as to what are the feasibilities of installing PET CT scan machines at Baleswar and Barampur. So if these two places are provided with the PET CT scan facility, I have a strong belief that the entire state population would be benefited, because now cancer has become a major disease like heart attacks. So these are the two major diseases, and the people of Orissa being financially not that sound, for them it would be a big help. So this is as far as the second case is concerned. And now coming to the third case, which is also of public importance, we have filed a case by way of a public interest litigation, saying that Orissa should be declared as a dry state. Dry state means there cannot be sale of liquor, any form of liquor. So now that, because there is a particular act that is called Orissa Prohibition Act, 1950 or 56, I'm just forgetting the year, I think it is 1950, where it says that all forms of liquor is banned in the state of Orissa except for medical usage. So basing on that particular provision, so we have filed again a PIL in the Orissa High Court saying that Orissa should be declared as a dry state for the simple reason because it violates the provision of that particular act. And secondly, by sale of liquor in any form, that is creating more of domestic violence. The families are getting affected. People are also getting affected. And the entire family system is getting destroyed. So this also has been taken seriously by the Honorable High Court. Now the court has asked the state to come forward and place before the Honorable Court on the next date as to what is the present status of that Orissa Prohibition Act. So that is where the present case stands, and I'm hopeful that something should come out. So these are the three major cases which I thought of placing before you. So that because these are all of public importance, and one day or the other, it will ultimately benefit the people of Orissa.
Indeed, sir, you have very well recapitulated all the three important cases that you are appearing for the petitioners. I would also like to point out here that, as sir said, in Arun Kumar Budhia's case, the Honorable Orissa High Court said that or mandated that police should upload FIR. This case came in 2012, and then after 1 year, Lalita Kumari versus State of UP, which we all know, if audience is from legal fraternity, they would be surely knowing that in that case also, the Honorable Supreme Court reiterated that it is a mandate for police officer to give FIR copy to the accused persons, to the person who is filing the complaint, and there were a number of guidelines or mandates given by the Honorable Supreme Court. So this is a quite a great case which we all must remember. If we are practicing criminal law, or if we are willing to do that in future in Orissa High Court or Supreme Court. So that's a great case again. And then
not only for the lawyers, it is also for the general public. You never know when a FIR is going to be lodged against you. If you do not know this particular provision, that this facility is available, then anyone can take you for a ride. So it is also beneficial.
Absolutely.
Not only for the lawyers.
General public also.
Exactly.
Yes, sir. Yes, sir. This is benefit for a general public also. Now, the second case about PET CT scan is again a tremendous, I must say, flight in the development of Odisha's health industry, and will surely benefit the people of Odisha who are suffering for cancer, or if they need any treatment for that, PET CT scans machines and all. So it is quite a great case of public importance. So, as you have appeared in a number of cases of public importance, and then you have an immense experience in practicing, I would like to know from you as to who are the eminent members of the bar. As you have practiced both in Supreme Court and Odisha High Court, you can surely tell us about the members of the bar who inspired you, or you have seen them arguing in a particular manner which you felt that they have done it beautifully, or you remember that particular instance. So if you can tell us something about the eminent members of the bar at your time, so that we will know the history of the lawyers who were there practicing at that point of time and were doing really good in their practice.
No, I'll start with the eminent lawyers of the Honorable Supreme Court, because I was practicing there for almost 15-20 years, and I was on the arguing side, because I never sat for the advocate on record exam, and nor was I an advocate on record for that matter. So since I was on the arguing side, and as I told in the beginning of our discussion, in Supreme Court there are two sets of lawyers. One is an advocate on record, whose primary job is to prepare the draft petition, file it in the court, then engage a counsel for arguing. It can be a normal counsel or it can be senior counsel. So now, as far as the senior counsels are concerned, there are many senior advocates in Supreme Court, but all are not of equal stature. I had the occasion of interacting or assisting some senior lawyers who are like Soli Soraji. Unfortunately, he just expired. He was the Attorney General. P.P. Rao was there. He was an expert he has also expired. He was an expert in service matter. And Santi Bhushan is there. He's a former law minister, and he's just too good for that matter. At his age also, he's around 85 plus. But nowadays he has stopped coming to courts. But in those days, he was fantastic. And there are many others. Like I just named 3 or 4. Ram Jethmalani was there. He has also expired. So there are many. Kapil Sibal is there. Then Arun Jaitley is there. I have worked with them. I've assisted them in many cases, and in some cases I have also appeared against them. So what I'm trying to say, as far as these seniors are concerned, I'm highly inspired by the way they conduct the cases and the way they deal with the cases and the clients. And another very important thing, which should be known to the young lawyers or the law students who are in the process of becoming lawyers. In Delhi, for that matter, if a person is designated as a senior advocate, the client cannot directly contact the senior advocate. It has to be through an instructing counsel or an advocate on record for that matter. So what happens when a client decides that, okay, I want to engage X senior counsel. For that matter, let us assume Falin element. So what, he cannot go directly to the senior counsel. So he will tell his advocate on record, I want to engage Falin element for my case. So then this advocate on record, he has to take an appointment from the senior counsel, and in advance he has to send the brief to his chamber, so that the senior counsel's office will instruct a concerned junior advocate in his chamber to go through the brief and make the notes, so that he can brief the senior counsel in the conference where the advocate on record or the instructing counsel along with the client would be present. So here what I'm trying to say, these senior advocates whom I just named, they were so sharp in their memory, knowledge, and whatever you may call it for that matter. And in Supreme Court, normally the briefs would run into 100, 200, 300 pages, depending on the nature of the case. And they would just glance through the briefs. And in a fraction of minutes, they would know which point to highlight and which point to harp upon, which is really something amazing. And that is one thing one has to learn. And it is really required to be learned for being a successful lawyer. And this has really helped me in my professional career, being associated with them at some point of time or the other. And this has really given me a real good exposure and experience. And not only that, these senior advocates, when they argue before the Supreme Court bench, they have a face value and a commanding voice and a force behind them legally. So, and the judges, because in Supreme Court what happens, supposing 100 cases are filed in a day, 90 cases are dismissed in the first go itself. So around 5 to 10% of cases are admitted in the SLP admission stage. You have to be very, and normally the judges, they give you 2 to 3 minutes per case on the higher side. So suppose now let us assume the brief is 100 pages and you are just given 2 minutes time. If you are not that sharp and you do not have that kind of an acumen, you cannot really point out which page you should rely and the judge should be convinced. Because if supposing, let us assume a particular point is at page 50, but you think a page 55 is more important, and you go to page 55 because the judge will just give you 2 to 3 minutes, and then you just miss the bus. So this is how, these are the things which one can definitely learn from the Supreme Court level, the senior advocates. So this is as far as the senior advocates of Supreme Court are concerned. Now coming to Orissa High Court, there are also many senior advocates, but the more eminent and proficient senior advocates have recently, in the last 1 or 2 years have expired. And as on date, there are many senior advocates like Vijay Mahanti is there. He is the senior most as on date. He does all kinds of law, including taxation. Then we have Bijen Rai. He is also a very senior counsel. Then we just lost Ashok Mukherjee, Ashwini Mishra, Rajat Rathore. They are all high caliber lawyers as far as Orissa High Court is concerned. But unfortunately, we lost about 4 or 5 of them in the last year. So these are the things. But again, to be very honest, though the senior advocates of our own High Court cannot be compared with the senior advocates whom I just named at the Supreme Court. They are no doubt they are very good at the High Court level, but at the Supreme Court level, they are no match. Because the reason being, because in Supreme Court, the senior advocates, they get various types of litigations to appear and argue. So they get a better exposure. Whereas in Orissa High Court, the nature of litigation, the stakes involved are, to that matter, very less as compared to Delhi and other high courts. So this is as far as the senior advocates of our own High Court and Supreme Court are concerned.
Very well pointed out on this particular question, sir, that the advocates, the senior advocates that we have mentioned are, we all know, if we are from Odisha and in this particular legal field, that these senior advocates have a great acumen and they certainly create a great impact and are source of inspiration for all the juniors of them, including law students. So that is quite a great answer for this question. Now, one basic aspect.
I'll just add one more point I just left out. And because I have that experience of Supreme Court, I've seen the leading senior advocates of Supreme Court. the way they deal with their juniors, the exposure they give them, which is beyond comparison as compared to our own High Court. I may be a senior advocate myself, but I don't have any hesitation in admitting this fact that we are no match as far as the courtesy, the other what you call exposures we extend to our juniors as compared to their counterparts in Delhi.
Absolutely, sir. I would also agree on that particular point. Being an intern in under advocates in Orissa High Court, from Orissa High Court and Supreme Court as well. Now, this brings me to a very basic question to ask you: is that what all aspect of being an advocate interest you the most, or are there any aspects which interest you least? Because for young law students, they must know that what in which field they are going to enter after graduating, and what should be their interest, and what
No,
aspects should be of their concern.
First of all, what I have seen of late, the students, those who are passing out from these 5-year integrated law courses, they are more interested or career oriented as far as the corporate job sector is concerned, or they want to go into judiciary. The primary reason being because there the financial security is there, which is not there in the legal profession in the initial days of practice. So what we are generally seeing, not only in Orissa High Court, for that matter, in all the high courts, the lawyers, those who are passing out through the 5-year integrated law course, they really do not want to come into this legal profession, litigation. They want to go in for corporate jobs because the starting salary can be a lakh of rupees, whereas in litigation, it will take you years to reach that figure. But at the same time, if a person is really interested in becoming a lawyer, full-time lawyer, and being enrolled in any of the bar councils of India, so the primary thing is he should not be really hankering after money. Money will come at one day or the other, but you should have a lot of patience and sacrifices. Maybe you may have to depend on your parents, because when I started my practice 30 years back, I'm openly admitting here in this platform, because as I just told in the beginning, I was just getting about 2,000 rupees what you call honorarium, or whatever you can say, and that was not sufficient to live in Delhi. But so I had to depend on my parents for some time till I got settled. The same thing also applies here. But Orissa being a little bit relatively less expensive place, it would be much easier for the lawyers to start the practice independent, to be in the litigation rather than going in for corporate sector jobs or trying for judiciary. In this process, what happens, we are not getting the real bright young lawyers into the litigation field. So this is a very big drawback. So hence, through this platform, I would humbly request all my young lawyers who are in the making of, who are in the process of getting enrolled before the bar councils, or who are in the process of passing out, including yourself, you should definitely consider taking litigation as a career rather than going in for corporate job. Another very important thing is, corporate job initially may be very lucrative. You may get a lakh of rupees to start with, but after a particular point of time, there will be a stagnation. 1 lakh cannot become 10 lakhs. But if you are in the litigation, initially maybe you have to struggle. You may not get anything, or you may just get a couple of thousand rupees, and you have to manage with that. But in the process of time, passage of time, this one, if you are getting 5,000 today, maybe after 10 years you can earn 5 lakhs, and the sky is the limit. So this is very important, which the young lawyers or the lawyers in the making should definitely consider and keep it in their mind before taking a final decision as to which field they should opt for out of these three, which I just told you. And the very important thing is the law students or the lawyers who have just passed out. So they have to be very sincere and dedicated towards this profession. There is no shortcut to this profession. You have to go through the same rough weather as far as this profession is concerned. It takes minimum 4 to 5 years for a lawyer to establish himself, to be on his own. So this 5 years period has to be overcome. This is one thing. And there has to be a lot of honesty and integrity, because that is very important. There has to be a lot of transparency as far as the clients are concerned. You just cannot take the clients for granted for getting some quick bucks. This is one thing which one should definitely keep in mind. Unfortunately, what is happening, what I have been seeing in my these years of practice, the lawyers, those who are just passing out, immediately from the day one, they want to make a huge amount of money, which is absolutely not possible and not correct also. So that has to be embodied in their mindset. No, this is not the right approach which you are following. You have to follow this part because there is a set guideline. Though there is no set principles, but you can say it's a set what you call, it can be termed as a guideline kind of a thing, that you have to follow these things to reach a particular level. Without that, it is practically not possible, which has to be really informed to the law students and the lawyers who are in the making.
Indeed, sir, and very well portrayed about the priorities that the law students should take into account while graduating and deciding about their further career in the legal field. If they want to go into judiciary or corporate or then litigation. I hope this particular answer given by you and the pointers given by you will be helpful for the fresh law graduates or who are in their fourth year, fifth year, or in third year of 3-year LLB to decide their career path. Now, as you said about being honest with the clients, and each and every case is important as concerned with the clients. This brings me to ask you a question regarding the importance of client satisfaction and how one should handle or counsel a client properly, because this aspect is not taught to anybody in our law school even, or not even taught to you by much of the chambers due to various other reasons. So if you can give us few pointers, few brief tricks on this particular point.
Because the first and foremost thing which a lawyer of some standing should keep in mind is that lawyers, the clients are like God to them. Because if the clients are not coming to that chamber, the lawyer cannot flourish, he cannot earn income. So he has to treat the clients irrespective of his strata in the society, whether it is he is financially off or he is of a lower income strata. But that thing has to be strictly kept in mind, that the client has to be given due weightage, irrespective of his status. So the moment this thing is conveyed to the client, so he automatically will develop a kind of what you call confidence in the lawyer he has approached. So this is the first and foremost thing, that the client has to be given due respect. Without this, a lawyer can never be successful. I can give you for granted. This is the first thing. And secondly, there should be a clarity as far as the client is concerned. Now, what happens, again, I'm sorry to say, but it's a fact. Suppose a client comes to any XYZ lawyer's chamber. He comes with a brief. It's not necessary that all cases are winning cases. Many cases, there may not be any legally valid points. And ultimately, once you file the case, the client has to suffer and he has to lose the case. The lawyer should have that kind of guts before the client to tell him, okay, I've gone through your papers, but you do not have a case to stand on merits. The moment you tell this, the client will automatically develop a more level of confidence and satisfaction towards you. And at the same time, you should tell him, you see, as far as my understanding of law goes, you do not have a very meritorious case. The chances of winning or losing is dash percent. So you decide. And if you still insist, I can take up your case, but never give a guarantee to a lawyer, to a client, even if he has a 100% case in his favor. Never give a guarantee. What most of the lawyers they are doing, they say, oh no, you have a very good case. We will file, we will get a good order. This is not the right approach. I strongly don't approve of this fact. So the moment you do these things, and another one important thing what one should do is, you should tell the client, you see, this is my opinion. My opinion is not final. In my view, you do not have a case to stand. Or maybe you have a case with 50-50 chance. If you are not satisfied with my opinion, then you are free to go and approach any other lawyer, take his second opinion and decide. If he gives you a better opinion and if he can convince you that you have a more meritorious case, you are free to approach him. So the moment you give these kind of answers to the client, he automatically will develop a confidence in you. And I can tell you with 100% authority that he will never leave you and go. The moment you give these things to the client, this is as far as the client's confidence building is concerned. Another important thing which also is highly essential to bring the client to your good books is when a client comes. Now, supposing you explain the client all these 3-4 points which I just told you, and the client is convinced, and he still agrees to go with you in filing the case. Then what should be done is you should have that kind of an infrastructure in your office, which is very important. That in front of your client, and for that also you should have that kind of an acumen in drafting. You should be able to draft the petition there and then before your client, so that he knows exactly what you are drafting, and he knows that okay, his case has been given priority irrespective of the fee consideration, and he still develops a further level of confidence in you. So this is another important aspect which has to be really kept in mind. And I have seen in Orissa, at least in Delhi it's slightly better, but in Orissa I have seen many lawyers, what they do, a client comes with a brief, they keep the brief with the fee consideration, and the client leaves, and the client never knows when the case is to be filed. This is happening, which is not a very correct approach. So this is one aspect. So these things has to be really kept in mind for developing the client's confidence. And the last and most foremost factor is for being a successful lawyer in this profession is this profession will help you in becoming a successful lawyer by word of mouth, because you cannot advertise, because it is banned under the Advocates Act. You cannot advertise, you cannot make any publicity. So how do you prosper? Either you win a case again through word of mouth. If a client gives you a case, and with your all efforts you put in that particular case, and ultimately you succeed, so then that client will go and tell 10 people that so and so person had engaged, and this is his background, this is what he had advised me, and this is the outcome. So automatically people will start running to you, and this is exactly what has happened in my case. So hence I am telling you with authority how this is going to help the young lawyers and the law students who are in the making of a lawyer. I'll give you one more example. When I shifted back from Orissa, from Delhi, sometime in 2007, after putting about 17, 18 years, I didn't have a single brief in Orissa High Court, because I never appeared in Orissa High Court during my stay in Delhi. Because as I told in the beginning, and you also pointed out in your introduction, I was mainly dealing with corporate clients. So I never had any interaction with the local bar at Orissa, for that matter. So, this is a very important one has to keep in mind. So you have to be very prompt and sincere in your approach towards your client. So that will really going to give you a big help. And secondly, as I told you, when I started in 2007 with a zero brief, I didn't have any clients. But somehow or other, because of my Supreme Court background, so people gradually started coming to me through some reference or the other. And in this process, as I told you, by word of mouth, by God's grace, today we have got more than 2,000 briefs in my office. So the bottom line is one has to be sincere, dedicated, honest, and transparent in your approach before your client, before your court, and for that matter, before any person.
Absolutely, very well. In a very well manner, you have described about the importance of client satisfaction and what all we as a young lawyers who look up to you in this profession should follow as to the client's counseling or handling is concerned. So that is a great explanation and a great answer given by you, and I personally will adhere to that when I join practice uh, after graduating. So thank you so much for that, for this particular question. Now, in the beginning, you have said that drafting is a important forte for lawyers. So this brings me to ask you a question as to what are the basic important things that a young lawyer who is joining practice should take care of while drafting, and what are the common mistakes that they intend or without any intention do in the drafting part. So if you can elaborate or put light on that part.
Before I answer this question of yours, I would give my own example. So that would be more easier for your viewers to understand what is the importance of drafting. As I told you in the initial conversation of ours, that my second senior at Delhi, he gave me an SLP to draft. I didn't know ABC of the SLP or the petition for that matter. I was just pondering over from where to start and where to finish. And I could not succeed. And ultimately, I had to return that brief to him. And thereafter also, because by then I decided to start my independent practice. And independent practice means you have to do the drafting. That is the first stage of, that's the first step. So now since I was not competent or I didn't have the acumen to draft a petition SLP, so what in Delhi in those days also, there were many lawyers of my contemporary, those who knew the skill of drafting, but they were not able to get briefs for some reason or the other. And there were some lawyers who had the skill of drafting. They had the briefs, but they could not argue in the courts. So these were different categories of lawyers. So what I used to do initially in 90s, I used to hire 2-3 such lawyers of my contemporary, and I used to pay them. I still remember I used to pay them 500 rupees for drafting of an SLP. And they used to draft. I used to get it because I was not an advocate on record also for that matter. I used to engage an advocate on record. He used to just put his signature. The drafting was done by someone. Signature is done by the advocate on record, and I used to appear in the matter. So this was the process I used to follow initially. But then one fine morning, I realized, no, this is not the cup of tea for me. I just cannot keep on paying 500 rupees to a lawyer for getting the drafting done. And in this process, I am not increasing my acumen as far as the drafting skill is concerned. And rather, I'm also losing money on it. So then I decided, no, I have to think as to how one can improve on the drafting. Then I started pondering about the issue. And finally, I came to a conclusion. What is the technique of drafting a petition? Now, suppose because I was in Supreme Court, it is slightly different as compared to High Court. First, let me talk about the Supreme Court, then I'll come to the High Court. In Supreme Court, what happens? A particular judgment is assailed in the Supreme Court by way of an appeal, especially petition. So that means the impugned order is under challenge before the Honorable Supreme Court. So now when you file a petition in the Supreme Court, there are two sections. One is grounds, question of law, and because Supreme Court is purely on question of law. They don't want facts. So one is question of law, and the second one is the grounds. So how to differentiate what are the grounds one can possibly take in the SLP and what would be the question of law? So for that, I just kept on analyzing time and again. Then I came to the conclusion I should take the judgment at hand and go through the judgment time and again. If you let us assume a judgment is of 5 pages, first 4 pages will just be facts which are not relevant for the case, because fact you can just copy paste. Okay, then the last page would be generally the observation part. The observation of the High Court is the crucial thing, because from those observations you have to take on what would be the question of law and what should be the question and what would be the relevant grounds. And from there you can frame your question of law and the grounds. That is how I developed this technique of drafting, and since then it has been my most favorite line of interest in this entire legal career, and drafting. And thereafter, I used to pay people 500 rupees to come and do drafting for getting my drafting done, and it just became the reverse. People came and started giving me drafting work. And today also, of course, unfortunately, since I become a senior for almost 8 or 9 years back, you are not supposed to do drafting or you're not supposed to interact with clients. So that has got reduced to a great extent, except I can just do the vetting part. My juniors, they do the drafting and I do the correction and just try to improve upon it. So I lose that. I mean, my main strong area I have lost because of this restriction being a senior advocate. But so this is how a lawyer should, a lawyer in the making or the young lawyers, they should try to develop upon the drafting skill. This is as far as the Supreme Court I told. Now coming to the High Court, because in High Court, again, there are two sets of petitions. One is a writ petition. Normally, when you file a writ petition, you have to file it basing on the certain documents which the client gives you. And you have to find from the those documents what are the relevant documents and what are the grounds one can make out from the documents, and where the state has gone wrong or the authorities have gone wrong as far as those documents are concerned in correlation with the concerned relevant act and the procedure rules framed therein. So that is how one can develop upon the drafting skill as far as the High Court is concerned. But again, in High Court, under 227, the High Court can sit in revisional powers where the lower court orders are challenged. They are also the same technique which I told you for Supreme Court. That also gets applicable in the High Court. Because once you have an impugned judgment at your disposal for being challenged in a higher forum, then the same technique applies. You can find out the grounds and the question of law from the said judgment. But here there is a rider to this effect. Before doing this drafting or developing your drafting skill, you should be thorough in the relevant provision of law. Until unless you are thorough with that subject, then you cannot do a proper drafting. Now let us assume there is a civil procedure court involved, and any section for that matter. So if you are not aware, now let us assume Order 39, Rule 1 and 2, that is for temporary injunction. On what all grounds a temporary injunction can be granted? If you are not aware of that rules and the procedures and the set legal judgments laid down by the Honorable Apex Court or by your own High Court, so then if you are drafting a certain petition, you may go wrong somewhere. So it is very important for you to know the latest position of law on the particular subject you are drafting, so that you do not go wrong or haywire. So these are the broad outlines which should help in your drafting. Another last important thing, as far drafting is concerned, you should try to be as short as possible. You need not use elaborate, fantastic, bombastic words, English language in your drafting skills. Many lawyers, they feel, no, if we use very high English standard languages with high words, it is absolutely a wrong approach. The more the simpler the draft is, it is easier for the other side to understand and also for the judge to understand, because no judges have the time to go through your draft, your petition line by line. So if it is simple language, it is easier for the judges also to go through and pass orders. So these are the broad outlines which one should consider while developing a drafting skill.
Absolutely pointed out with quite a relevance about the pointers regarding drafting work and how one should adhere to the pointers that said by sir in this particular question for the answer of this particular question. And I am really sure that this will help a number of law students, a number of young lawyers uh, to draft a particular petition or anything, client or anything in a proper manner while adhering to the pointers given by you. Now, as I have already covered more than 20 questions, I would like to call upon my co-host Jyoti Prakash Datta to this live session, who will take upon the second phase of questions that we have prepared for you. And I would really like to bring this to the notice of our audience that this second phase of questions are really important concerning to the law students or law as a lawyer. So please stay tuned and you will get to know a lot of things on this particular from the particular answer given by our honorable guest speaker. So stay tuned and listen to the questions and the answers discussed between Jyoti Prakash and Goutam sir. So Jyoti, your mic is all yours.
Thank you.
Thank you, Devasis. I was listening to your questions. Those questions were really very much important, and sir has lucidly explained each and every question in a very in-depth manner. So, sir, I was going through those particular questions that were posed by Devasis, and you have also explained the experience that you had in the Supreme Court. You have explained about senior advocates with whom you worked and with whom you have seen the Supreme Court working. Sir, you have also worked for many years, more than 15 years in the Supreme Court. So, in that span, there were several chief justices. More than 15 chief justices were there in that particular span. And apart from chief justices, there were several other judges. So, I want to know from you, sir, who all are the judges? Do you think that they are the inspirations and should be followed by each and every persons of this generation? Though it is very controversial question. It can be a very controversial question that we cannot just differentiate between judges. But still, if you think you have to answer this particular question, to whom you will choose?
Well, you see, it's definitely a very difficult question to answer and also a controversial one. But the fact remains, one has to appreciate and accept a person, a judge who is being elevated to the Supreme Court. He must be the best of all among all judges in the country, in the High Court for that matter. Otherwise, he will not be just merely by seniority. A judge is not promoted to the Supreme Court. So that is the first and foremost criteria which one has to keep in mind before addressing this question of yours. So it would be very wrong on my part to pinpoint and say who is good or who is bad. That is one important thing. But at the same time, you have to appreciate in Supreme Court also there are two sets of procedures where the judges are appointed or elevated to the Supreme Court. One is from the High Court. They can be either a Chief Justice or a puisne judge who is promoted, elevated to the Supreme Court. This is one set of procedure. And the second one is in lawyer practicing can also be directly appointed as a Supreme Court judge. So here I'll just give you 2-3 examples. One was Justice Kuldeep Singh. He was elevated directly from the bar to the bench. And in my opinion, he was a blunt and a fantastic judge, because I was practicing during those days and I've appeared before him in many occasions. This I'm saying because when a person is directly elevated to the Supreme Court, as compared to a person being elevated from a Chief Justice post or a puisne judge, so then naturally there has to be some extra edge. Otherwise, why should a person among thousands of lawyers practicing in Supreme Court, why should a particular person be appointed? This is one. This is as far as I told you about Justice Kuldeep Singh. Then recently we just had Justice Indu Malhotra. She was also a practicing advocate. She was an advocate on record in Supreme Court. I was also practicing there during her time. Then she was designated as a senior advocate by Supreme Court. Then she was again appointed as a Supreme Court judge. And recently she just retired. Like lawyer, I'm just forgetting his name. So these were the 3-4 persons who have been directly elevated to the Supreme Court. I would definitely, in my view at least, in my humble view, with my limited knowledge in law, whatever you may say, so these were outstanding judges. And plus the other judges who were also appointed to the Supreme Court, before whom I had occasions to appear, I found many of them to be very fantastic and had a very good grasping power, and they were very fast in decision making. I really liked Justice J.S. Verma. He retired as the Chief Justice of India also. I have appeared in many occasions before him. I found him to be a very fantastic judge. So there are many judges. I do not want to elaborate further. But my basic point is, a person is directly being elevated, he should be given a more edge as compared to the other judges.
Indeed, sir, rightly pointed out. And there are only few judges, only 8 judges who are directly elevated to the bench from the bar. And now we have also seen Justice Arif Nariman will retire without even being designated or being elevated to the post of Chief Justice of India. He has dedicated his practice only to decorate the bench. And these are the dedications which should be appreciated by all the young members of the bar, sir. Indeed, sir. Sir, another question. You were telling about that we should not always give assurance to our clients, no matter how much we are sure about our case, but still we should not ever give them assurance. And this advice was once given by Justice Deepak Misra, former Chief Justice of India. I was going through one of his lectures. He told that however senior and experienced you are, no matter how much sure about you are about case, but still you should not give assurance to any of the clients. Sir, if there is any, I have one question more. If there is any doubt about your moral ethics and about the case, I mean, whenever there is a conflict of client's interest and your moral or your ethics, how lawyers should deal with that particular situation?
No, as far as the lawyer is concerned, this moral ethics should take a back seat for the matter, for the simple reason, a lawyer, once is approached by a client, he is duty bound under law, under the Advocates Act also, to appear for that client until and unless there are other adverse infringes which can be considered. Like supposing if you had been appearing for the other side party for whom the client has approached you, then there are certain reasons where you cannot appear for that client. So, but otherwise, there should not be any moral grounds for refusing a case. When that is at least I feel, this is my view. A case cannot be decided whether to be taken or refused on moral or ethical, on moral grounds. This is irrespective of the nature of case actually. Because ultimately, as a law officer of the court, it is your duty to place the facts, irrespective of the nature and sensitivity of the case, and it is for the court to decide. So with that, the moral doesn't come into picture. This is my view, at least.
Indeed, sir, that is very rightly pointed out, and this was also told by the same point was told by Mr. Ram Jetmalani. He was the senior advocate, eminent member of the bar. He also, when he was questioned this particular question, he said that the first moral of every lawyer is to represent his client, and if it is violated, then no other moral can be protected. Definitely, this is a very correct answer, sir. And sir, then you have a such huge amount of experience. You have appeared for several parties. You have already told us that you have more than 2,000 briefs with the grace of God. So, sir, you have humongous experience. So, can you tell us some witty conversation or any conversation with the bench which you have regarded as one of the best conversations?
Well, I cannot say whether it is a best conversation or a bad conversation, but I would like to give one example, one particular incident. I'll not be naming the judge, nor the court, nor the parties, etc. But definitely it was a very satisfying experience, satisfying moment for me. The reason being, I was handling a case for one of the parties. The matter was heard and the order was passed by one of our high courts in the country. I'm not naming the high court because that would not be proper on my part to name, to go beyond a particular point. And the order was passed in such a way that it had two different meanings actually. Like in one part of the order, the concerned person was allowed to surrender and be released on bail. And at the same time, there was an order, observation by giving liberty to the police to arrest the person before he surrenders. So there was a conflict of observation in that particular judgment. Am I audible? Am I audible?
Yes, sir, you are audible. You can continue. I think there is a glitch with Jyoti Prakash's
Yes.
connection, but then you can continue by while he will come.
Sure. So now what I was trying to say, so there was a conflicting observation in that particular judgment. So now what happened? So in the meantime, before the person could surrender, the police arrested the concerned person, the accused. So police was within his powers and the rights to arrest because the order said so. The party was given, the concerned person was given liberty to surrender, but without a time frame. And before that, the police arrested him because there was no time frame, and the order clearly said that police is free to act upon under law. So now police arrested. So the moment the person was arrested, this accused person again filed an application in the court saying that the anticipatory bail was allowed. Then how I could be arrested and how could the police act beyond the scope of the order? So I interfered and I argued vehemently before the concerned judge, saying that, see, as far as the order is concerned, you have given liberty to the accused person to surrender. But for some, it may be inadvertently, you have not given a time frame to surrender. But at the same time, you have given right to the police to arrest. So now the police has arrested. So how could you blame the police of arresting the person when the anticipatory bail was allowed? So this was my point. And in the open court, the judge admitted his fault. Yes, I have done a mistake. I have done a blunder. I should not have done this because my intention was never to grant bail and allow the police to arrest. But it was the goodness of the judge to admit in the open court, yes, I have committed a blunder, I have committed a mistake, and in future I'll be careful. This shows the what should I say? The conduct, no, not conduct, won't be the right word. The gracefulness of the judge for admitting his mistake in the open court, and that gave me a lot of satisfaction in my entire professional career, that I have achieved something. At least I could place before the judge in the open court, no, this is not done. You have not done the right thing. So this is one incident in my entire career which I thought should be brought to your notice.
Indeed, sir. That is an interesting story. I think many people will find some inspiration from that story as well. So, sir, the next question is, you have been junior under several lawyers, you have already mentioned, and you have learned many things from your seniors. So, is it compulsory for every junior lawyer to join a senior's chamber, or he can start his practicing without joining the chamber?
Absolutely, it's not necessary to work with a junior under any senior. Like as I told in my own case, I have been on my own in my independent practice just after about 2 months of my practice with 2 seniors in Delhi. If I could do it, why not the other lawyers as on date who are about to pass out, the law students, or who are in the process of getting enrolled, why they cannot do? That this is one thing. And secondly, I just in the initial stages I referred to this book, which this person who was a very eminent judge and a very highly decorated lawyer in the pre and post independent stage, he has also never worked as a junior with anyone. Right from day one, he also practiced independently. So there is absolutely no necessity for being working under any senior advocate for some length of time. But however, there is a rider to this. Am I there? Are you able to hear me? Are you there?
Yes, sir. Yes, sir. I think there is a glitch with Jyoti Prakash connection. So
yeah.
that's
So
why
what I'm trying to say, there is no hard and fast rule for the young lawyers to work under a senior. But to overcome this situation, my sincere advice to these young lawyers or the lawyers in the making would be, during your 5 years of this integrated law course, or maybe for that matter 3 years of law course, what you can do is, during these 3 years or 5 years, if you can find time from your busy schedule of your college education, if you can get associated with any law firm or any lawyer for that matter, and try to develop the advocacy skills, starting from drafting, court craft, and all, because you cannot accept one thing, you can do rest of the things. You cannot go and appear in the court, but you can go and sit in the court, see the court craft, you can do the drafting, which can be finally settled by your senior, whoever you are attached to. So these are very important things. If you do these things during your college days, then definitely I'm 100% sure once you pass out and you take your license, you can immediately start your own independent practice, as I did 30 years back. And the person whom I just showed you in the book, he did it 75 years back. If we could do it, why not the present generation? I'll give you one bright example. I had a law student with me. He was also from your college. I'm not naming him. He just passed out about, I think, 7-8 years back. He did a 5-year law course. So during his 5-year law course, and as my main office is in Cuttack, though I have an office in Bhubaneswar also, so he used to every day, because I think those days the classes were from morning to 11 or 12, something like that. I'm not very sure. But anyway, every day in the afternoon, he used to go to my chamber at Cuttack without fail. And he used to be there in my chamber till evening, do whatever work assigned to him. And I think he started from his 3rd year onwards, 3rd year, 4th year, and 5th year. And in certain cases, like in consumer forums, you need not be a lawyer. You can send your representative also. He used to go and appear in consumer forums as a law student, also being duly authorized by the concerned counsel or the client. So the moment he passed out his law LLB and took his enrollment with the Bar Council, from day one, he started his independent practice. He practiced in Bhubaneswar Court, and he also practiced in High Court. And from day one, he started his independent practice. He opened his own office, and you won't believe, From day one, he was himself a junior with hardly 1 day of experience at the bar. He appointed 1 or 2 juniors with him as lawyers with him as juniors. You can call them juniors because if someone is working under you, naturally he has to be a junior or your associate for that matter. So the bottom line is there is no hard and fast rule for being working under a senior, provided if you are following this procedure or the principle which I just told you. This should definitely help, in my view at least.
Indeed, sir, it will definitely help to many students that are hearing this conversation. And sir, after that, I will definitely try to know from you. So there are several confusions among the students that how should they what should be their approach to read a particular judgment? Because we have seen in the past that there are several judgments which are very lengthy, and they're of several pages, like 1400 pages of Aadhaar judgment is there, and right to privacy judgment is also 500, 600 pages. So what should be the approach of students to read those particular judgments?
Yeah, it's a very good question. You see, before reading a judgment, because always it is not possible to go through the entire judgment running into hundreds of pages. But there are some judgments which are 10, 20, 30 odd pages. The judgments which are small in length, so those I would suggest for the juniors to read in detail, right from first page till the last paragraph. And the judgments which are too lengthy for that matter, so what you can do, you can first read the head notes. So once you read the head notes, from there you can point out what are the relevant points of law discussed. And normally what happens in those head notes, the relevant concerned paragraphs are mentioned in the head notes at one corner of the end of the head note. So what you can do after reading that particular head note, then you can refer directly to that paragraph. And you can read that paragraph so you know exactly what the court wants to say and what is the law on this subject. So this is one way of reading judgments. But as far as practical, it is better if you read the entire judgments, though the judgments which are not very lengthy. So that will help you in accumulating your knowledge and knowing the latest position of law. This is one aspect. And the second important aspect which I would like to highlight to your law students and the young lawyers, which I have seen in the recent past. So most of the young lawyers, or maybe for that, this is also applicable for the law students as well, because in the ultimate, if they were going for practice, if they are going to follow the step which I'm going to tell you now, that is really going to help them in a great way. The fact remains, when you are reading a judgment, first of all, you should make it an habit, irrespective of you have time or you have no time. You have to dedicate at least half an hour, 1 hour, 2 hours every day as a matter of principle without fail to read judgments through of any journals. So you can decide which journal you should read. What I would suggest, it is better to go through rather than going through a High Court journal, you should you should get hold of a Supreme Court journal. There are so many SECs there, AIR Supreme Court is there, Judgment Today, there are Supreme Today, so many judgments are there. So as a matter of principle, as I told you, every day you should read half an hour, 1 hour, 2 hours, depending on the time schedule you have. And when you're reading these journals, because all these judgments cited in these journals may not be of that great importance. Because most of the judgments are being reported, but out of all the judgments, supposing 100 judgments are reported in one journal, out of that maybe 10, 20 or 30 are of great importance, which you can visualize after reading, no, this is an important subject or important citation, which can be treated at a future point of time. So what you should do, you should have a diary readily available with you. It should be it should not be a small pocket diary. It should be a big diary, maybe of at least 200 to 300 pages. This you should listen minutely what I'm trying to say. It is really going to help the young students. This diary should be indexed starting from page 1. If the diary doesn't contain pages, it should contain pages starting from 1, 2, 3, 4 till the last page. Now, let us assume you take SEC. SEC, 2021 volume 1. I'm just giving you hypothetically. And you start from page 1. The moment you start going through these pages, now at page 10, supposing there is a judgment, and you find that judgment is of some importance. Let us assume this judgment is with regard to Securitization Act, which is under the banking laws regarding this seizure of collateral securities. Let us assume section 13(4) of the Securitization Act. After going through that judgment, you find, no, this is an important judgment which can be of help for me in future. So what you should do after going through that judgment, first page of that diary which I told you, that you mark it as Securitization Act, okay, in the top. And the judgment which you have just read, that you just give a short citation. Suppose in 2021, volume 1, SEC, page 59. And you give the cause title of the judgment and the gist of the point. Supposing if it is dealing with section 13(4) of the Securitization Act, you just write section 13(4), so and so, and what it deals with. So section 13(4) is with regard to taking possession of the property, physical possession of the property. So what does it deal? So you write section 13(4), physical possession, and so and so. Then you go to the next page of that journal. Supposing this was at page 10, now at page 20, you find a relevant judgment pertaining to Hindu Marriage Act. Supposing it relates to mutual divorce under section 13B. So then, because through passage of time and through your own experience, once you start reading on a regular basis, you can know which judgment is important for your future career, which judgment can be of relevance to be relied upon in the courts at the time of arguing. Because once you are relying on the Supreme Court judgment, that becomes binding on all the courts, including the High Court, including our own High Court. So as I told you, now at page 20 of that journal of 2021 volume 1, you have come across a judgment of mutual divorce under section 13B of the Hindu Marriage Act. So now, see, page 1 of the diary is of Securitization Act, I just told you. So on an average, you should leave about 4 to 5 pages for each act. So now page 1 to page 5, you earmark for Securitization Act. Page 6, you mention Hindu Marriage Act. And in that, you give that citation. Likewise, you keep on adding judgments as and when you keep on reading. So you will see after a passage of time, maybe after 6 months, 1 year, 2 years, you will have a full diary containing different voluminous judgments which are relevant in the field of law, which are going to help you in the future career of yours. And this will really help you. I can just tell you point blank, because I have been following this. Otherwise, I would not have been telling you to follow this, because I have seen myself as to what help it is giving. Because now, of course, you see, you may just counter and say, why should we follow this diary method? Now everything is available online. But again, at the same time, we have to see how many people in Orissa, for that matter, because when we are talking, we are mainly dealing with Orissa students or the Orissa young lawyers. How many people will have access to Manu Patra or for that matter SEC online? Because it's a very expensive, it costs about 30,000-40,000 rupees. And every year you have to subscribe, renew it. And for that you have to have a laptop. And so many other things are there. So whoever can afford that, nothing like it. But at the same, even if you can afford, then also it is highly essential. You should read it on a daily basis and adopt this diary method, which I just told you. Over a period of time, that is really going to help, and it is really going to change your entire career while arguing. This is my suggestion, at least. Are you there, Jyoti?
I think there is a problem with his internet connection.
Right.
So, anyways, you have very well described about how should you go about with the reading judgments and what all pointers you should keep in mind while reading judgment, and how can you get a holistic benefit out of reading judgments by keeping it in a diary method, or if you are more technologically aware person, sound person, then you can keep it in Word files, if I am correct. So that will obviously help you in your long run if you join judiciary, if you join litigation, because you, yes sir, because you will have a bulk number of cases at a straight point of law which you can use directly. You don't have to or go into those online resources and search them again and again on that point. So that will surely be helpful for everybody who is from legal fraternity.
I will just add one more thing as far as the diary is concerned. Like, let us assume you have already put in 6 to 8 months of hard work reading journals every day, and in this process, your diary has been filled up for about 50 to 100 pages. Now, after 6 months, you come across this mutual divorce case, and you want to know what is the latest case law. You don't have to go through the net, search online, do this, do that, ask your seniors, juniors in the court, run around, find books from the library. You just take out your diary, take out Hindu Marriage Act, page number 10, and you just see what are the leading laws you have cited in that page under the 13B of the Hindu Marriage Act. So that solves your purpose. So that is how it really saves your time, and it will make wonders for you.
Indeed, sir. Now, as we know about client counseling, we know about drafting, we know about how to back up ourselves with good number of judgments on a particular point of law. Now, this brings us to ask you a question regarding researching. Now, researching obviously has changed since you have started practicing and have have taken a tremendous leap. Till then. So if you can even tell us something on the point of researching skills and how should we inculcate that, how should we develop that, then that would be great for our viewers.
No, as far as researching skill is concerned, what I just told you in the last previous question, I've almost answered that. Researching means what? You have to go through judgments. How do you go through judgments? Until unless you make a regular habit of reading journals, you cannot. Researching means ultimately you have to go through judgments and find out which is relevant for your particular case. So the one which I just answered in the previous question, I think I have already answered this question of yours, and there is nothing much one should do beyond what I've told you in the previous question. The bottom line is you have to have a regular habit of reading every day, at least for an hour, without fail, come what may. No excuses to be accepted.
Indeed, sir. If Jyoti Prakash, your connection is stable, then you can continue with the next questions.
Indeed, Devasis. I apologize for the network interruption, sir.
It's okay.
Yes. Sir, you have already discussed about the importance of reading judgment, and you have also told us how to keep note of all these judgments, and it will be of much help to all the students out there and also to the lawyers. And after that, I would like you to say something about the value of foreign judgments. Like, sir, we have seen in the past, while deciding the cases of right to privacy as well as homosexuality, several foreign judgments of the US, like Loving versus Virginia, Roe versus Wade, were referred. Uh, as we know that these judgments are not binding upon our courts, but still they have persuasive value. So, should we read all these foreign judgments?
Honestly speaking, if you ask me, in my entire career, I've never read a foreign judgment. Because you see, the concept of foreign judgment is not very much practically applicable in our country, because this society, which actually my battery is also running low, I may just shut down anytime. So, 1 second, please.
Sure.
So what I'm trying to say, the morality or the normal society's culture, supposing we take the culture of USA as compared to India, it cannot be compared, because there the standard of living, their morality, their culture, everything is different as compared to ours. So how does that judgment, which is binding in USA, can be made applicable to our country? So I do not vouch for that. And honestly speaking, I have never read a single judgment in my entire career of more than 30 years. So I would definitely say no to this question of yours.
Indeed, sir. Sir, another thing that is very unconventional, but still I want to know from you, sir. You have been a junior lawyer for several years, and after that, you have been designated as a senior advocate. So, what is the difference between being a junior and later being a senior advocate? What is the difference between all these kind of experiences, sir?
Yeah. First of all, let me tell you, many people, they are not aware as to what is the real meaning of a designated senior advocate. Normally people, in fact, the young lawyers or the law student, they also, I think, I may be wrong, but they have a normal notion. Who is a senior lawyer? A person with gray hair, a person having the 30, 40
There is
I
certain
think
network error
yes.
on Sir's part. However, he will join us soon. So I would request all the attendees to stay tuned until he joins us, because there are a few other relevant questions that will be asked by Jyoti Prakash, and Sir will be addressing on those questions, and that will surely be of a great help to all the viewers of this video and live session. So please stay tuned.
I would request all the viewers to please stay tuned with us. Sir will reconnect with us very soon. Sir was discussing a very pertinent topic, and he will also throw some light upon other topics as well. So please stay tuned with us. We'll be reconnecting with him very soon.
Can you hear me now?
Yes, sir. Yes,
Yes.
sir. Yes.
Yeah, sorry,
Yes.
my battery went off actually. So what
No,
was
sir.
I
No.
just saying? Yeah, what was the question you were asked? I just got disturbed actually.
Yes, sir. What is the difference between the experiences of a junior
Yes,
advocate
yes,
and a senior
yeah, right.
advocate?
So
Yes.
what I was trying to say, basically, most of the people, they do not know the basic difference between a designated senior advocate and a senior advocate. They think a person with gray hair, having put in 40, 50 years of practice, being 60, 70 years, is a senior advocate. But actually, that is not the case. A senior advocate, one doesn't become by choice. For becoming a senior advocate, the full court of the High Court where you are practicing, or the Supreme Court, as the case may be, all the judges will sit together and they will decide whom to nominate or designate as a senior advocate. And there are certain criteria, like your numbers of years of practice, number of cases you have handled, what is your monthly, yearly income, and there are so many other criteria. That is how a senior advocate is designated. And so the age is not the criteria for deciding a senior advocate. Okay. Like I became a senior advocate at the age of about 47 or 48. It depends. So it varies from person to person. But there are certain restrictions as far as a senior designated senior advocate is concerned. So once you become a designated senior advocate, but unfortunately, again, here in Orissa, people are not strictly following this system which is defined under the Advocates Act. Once you become a designated senior advocate, you are not supposed to directly deal with clients. You have to you have to be dealing with clients through the instructing counsel, or for that matter, your junior associate or whoever is there. This is first. And as a senior advocate, you are not supposed to do drafting. Drafting has to be done by the junior advocates or your associates or any advocate for that matter. What you can do the settling of the draft. You can do the vetting part. So these are the basic differences. And once you become a senior advocate, your uniform code, your dress also changes. The senior advocates, the gown and the jacket which they wear, the same dress is also being worn by the High Court and Supreme Court judges. So these are the basic differences as compared between a senior advocate and a junior advocate. So people should be very clear in their approach before deciding, yeah, before commenting as to whether a person is a senior advocate or a junior advocate. Like for another example I'll give you, supposing a person has about 40-50 years of experience, and he says many people, by just for the heck of it, they say I'm a senior advocate, but they may be saying so, but when they write anywhere in the letterpad or in the visiting card or in the or any other document, they cannot write the word senior advocate after their name. Irrespective of their age, experience at the bar, they can address right advocate. Senior word they cannot use. This senior advocate word can only be used only by a person who has been designated by the concerned high court where he or she is practicing. So these are the basic thing. Another very important thing is a senior advocate is not supposed to sign because he cannot deal with clients directly. So he cannot sign Vokalatama. Senior advocates are barred from signing Vokalatama. They have a separate memo of appearance which they can file, and that memo of appearance is a request kind of a thing by an advocate requesting the senior advocate to appear on his behalf in a particular court before in a particular matter. So this is the basic difference between an advocate and a senior advocate.
Indeed, sir. You have very well differentiated between a junior advocate and a senior advocate. And even if some persons say that because of their experience they are senior advocates, but they are not designated senior advocates, they can. Indeed, sir.
Definitely not.
Indeed, sir. So they can be termed as senior lawyers, but they are not senior advocates, sir.
They can be
Indeed,
called as
sir.
senior members of the bar.
Indeed, sir.
They
Indeed,
can be
sir.
called as senior members of the bar, but they cannot be called as senior advocates.
Indeed, sir. I think it has basically thrown some light upon this aspect to all the participants. And after that, sir, we have some other question. Like you have been a senior advocate for years now, so there must have been some less time for doing anything else than law. But still, do you think that law students should read something else from the law? Because everything cannot be confined to the 3 years of law. Some people should read other books apart from law books. So, what should be your advice to the younger generation? What they should read apart from law, sir?
Well, to answer your question, if I take my own case at hand, I have not, because I'm not a voracious reader for that matter, not a reader absolutely. I don't read any books besides law books. So far in my entire practice career, I have not read any magazines nor what you call storybooks. So I have just confined myself to the law books. What we can otherwise do, one should read newspapers, because in newspapers also you come to know about the latest happenings and what are the new rules or acts are being passed by the parliament and all. So at best you can read the newspapers and watch news channels. And I don't think there is any necessity of reading outside magazines. I don't agree, because I have never done that.
Indeed, sir. Once we enter into law, we should more focus on law. So that is a very good advice, sir. So after that, I have last question. We often ask this to our interviewees, so it is our honor to ask you this question as well. So you have passed from your law school many decades back. So do you have any regret that you couldn't do something while you were a law student that you want to do now?
No, I'll just rephrase your question. But rather, what I would appreciate if you would have asked me, was I regret? Am I regretting of having passed from a normal? Because that time Madhusudan Law College was just a normal law college 30-40 years back. Now it has become a university, as compared to having passed from a national law university or from a high stake law college. If that would have been your question, I would have been more happier, to be honest. So I'll tell you,
Indeed.
my personal opinion is passing law from any college doesn't matter. Whether it is National Law University or Delhi University, Delhi Law Faculty, or Utkal Law College of Utkal University, any college. Because my personal feeling is whatever the students are being taught in this 5 years of law course hardly helps them. Beyond 10 to 20%, it doesn't help them in their real-time practice. So whatever you are being taught theoretically, it doesn't have any value in practical life when you start your practice. So this is one very important thing. So whoever comes to me, many students, they come with their parents just for counseling and guidance. Ki, what should I do? Should I put my son, daughter in a reputed law university spending lakhs of rupees per year, or should I just put him any damn law college? My answer to them always is, if you ask me personally, any law college is fine, because whatever they are being taught there, it doesn't help them much. I think you can just judge for your own self what I'm trying to say, whether it is justifiably correct or wrong. So because ultimately what happens when you pass out, when you start your practice, when you go into the real practical field, that is where the things start counting. Because now whatever you have been taught theoretically, but if you don't use it practically, and if you do not go through the latest case laws or go through the acts, relevant provisions of the act, it will not help you. So any law college for that matter is absolutely fine, first. Second, once you start your practice, what I have seen with my past experience, when a client comes to you, he doesn't come to you by seeing from which college or which law university you have passed, or what is the percentage of marks you have scored, whether you have got a first degree, a first division, second division, or a gold medalist. These are absolutely bullshit. I don't agree to this. Rather, the client comes to you, and if you can convince the client with your knowledge in law, that will help you. And you should be able to convince you by doing your own homework, by going through the case laws and other materials available with you, so that will help. So these are the fundamental principles which are very important for a student to decide whether to go in for a branded law university, or for that matter do LLB course from any law college. One. But however, I would just like to put a rider to this. This is applicable for only students, those who aspire to be lawyers, be litigation lawyers, or for that matter, lawyers having a license to practice. But those who want to be going into the corporate sector, for them, there may be a slight difficulty, because these corporate world people, they think persons passing from a reputed national law university or a branded law college, they are more well equipped. So they try to take people in the placements from those colleges. There you will lag behind. So first you have to decide what is your ultimate aim in life, in your career, whether you want to go in for corporate job or you want to go into litigation. If it is corporate job, then naturally spend lakhs of rupees going for a branded law college. But if you want to go in for litigation, follow my advice, just join any law college, try to attend as many classes as possible, and in your free time, get enrolled, get attached with a lawyer's office or a law firm, try to learn the intricacies of litigation. So by the time you pass out, you know exactly where you stand and you start your independent practice. So you save 3 years of your professional career's time, and you also save your parents valuable money. These are my views, at least.
Indeed, sir, that is a valuable view, and we can also see there are many examples. Indeed, none of the CJIs are from any national law universities. There are none of the indeed, sir. And we have also
Because the national law universities have come up recently. Earlier, the
indeed,
national
sir.
law universities were not that 20 years back. So then you cannot say that the other law colleges were not producing good lawyers or good judges. So that's
Indeed,
not
sir.
actually correct.
Indeed, sir. So there are so many good advocates. There are so many senior advocates. Those are product of state universities, and we have also an example for us. You are also from in a normal law college, and that is very much inspiring for us. That we can also do.
Not only normal law college, and that too having not attended any classes. So it's
Indeed,
ultimately when you enroll yourself as a lawyer, you have to be dedicated from that day onwards to your profession. That will help.
Indeed, sir. So there is so many saying of senior lawyers that they started their law school after passing their law school. So this is a very
Because there is no end to law, and there is no end to learning as far as a lawyer is concerned.
indeed, sir. So, sir, the last thing that I will ask, what would be your advice to all the law students who are watching us, and not only the law students, but also the young legal professionals as well as judicial aspirants? They are very much inspired by you. We can see the chat box full of compliments are coming. So, what should be your advice to them, sir?
My advice to them would be, if they have seen, if they have meticulously heard what I have said, and if they have faith in me, and if they feel that I have achieved something in my life, in my professional career, then they should follow what I have just said. That is my final answer.
Indeed,
Because
sir.
it is ultimately the confidence level which matters actually. Because whatever I've been saying in the last 2 hours or 15 2.5 hours, if if I have not been able to build a confidence level with your viewers, those who are law students or young lawyers, then I think I've just wasted my time. Would you get my point?
Indeed, sir. Indeed, sir. So there is no doubt that you have inspired so many students. We can see their responses. We hardly ever get so many responses. We have flooded with many of the responses, not only here but also in WhatsApp. So it was a very good session, sir. So I would
I
request
can, I, I
Devasis.
can just I can
Yes,
just tell
yes,
you
sir.
one thing. Once the session is concluded, I mean, you can just share my number with whoever has any questions, and I'm open to guide them and help them in whatever limited way I can. And they can come to my Cuttack office or Bhubaneswar office after the lockdown and COVID situation improves. I can try to just guide them to my best of ability. Without any hesitation, they can contact me. That much assurance I can give you.
Indeed, it is your humility, sir, and we are very much inspired, and we are very much proud that we have a member in the bar like you. So it is we are very lucky indeed. So I would
No,
request the
because
yes, sir.
because
Yes,
because what I have gone through in my earlier days of practice, I don't want the present generation or the young lawyers they should face. So this is this is at best I can do for them.
indeed, sir. The senior members who have gone through so much struggle, they're inspiring us, and we should do better in our life. And that is very much inspiring, sir. So we have discussed many things in this session. Devasis took many questions, and he asked you many questions about your childhood, the early law school days, and your early days in the bar, as well as working under various seniors. And I have also asked several questions about judges and your experiences, and apart from that, the tricks to read judgments as well as drafting. So there are many questions that are discussed here, and those will be of much help to everyone who are listening to us. So before parting, I would request Devasis to come on the screen. Devasis, if you are there, please come on the screen.
Yes.
Indeed. So it was really enthralling to see you, sir. And we had expected only an hour or an hour and half an hour from you, but you have gone beyond our expectation, and we have come almost to 2 hour and 2.5 an hour. So it was very much inspiring, sir. And
Thank you so much.
this 2.5 an hour are very much insightful. There are many informations, not only facts but also experiences, and we can get some facts from books and from many other sources, but experiences are invaluable, and we have got that only. So that is very much important, sir. So
Thank you so
before
much.
parting, indeed, sir. Before parting, I would request Devasis to say some words, and after that we can end this session.
Sure.
Yeah, thank you, Jyoti, for calling me at the end of this session for saying few words, or rather, I would say a vote of thanks, a formal vote of thanks to Gautam sir, because I have just insisted him for once, and he agreed for this interview session, and this clearly shows his humility, his humbleness towards law students and young members of the bar. And apart from that, I am really grateful for this session, as this was This was excellent session. This was insightful. This was loaded with a number of pointers, important pointers, number of facts, number of I would say a number of tricks and tips that would be helpful for our viewers. That will be helpful for young law students, young lawyers. Sir has immensely and greatly discussed about drafting, researching, and judgment reading, client counseling tricks, and this will surely help everybody who views this video and who are live in this session. So sir, I am really grateful, I am really humbled that you agreed to this interview, and I, on behalf of Jyoti Prakash and my team Lex Cognoscenti, are highly grateful for you that you have consented for this, and I am sure that with your the acumen, the knowledge, and the sharp conduct that you have shared here will be helpful for everybody. We are really humbled and we are really grateful for having you on board with us today evening, sir.
Thank you so much for having invited me. I hope I have given some light of the day to the young aspirant lawyers and the law students in the making of lawyers. And I hope I wish them all the best in their future endeavor and the future legal career. Thank you so much.
Thank you so much,
Grateful,
sir.
sir.
We hope that you stay safe and stay healthy in these COVID times. Thank you so much, sir.
Thank you so much. God bless.